Garner. This work was selected because of its enduring effect on lawyers who are involved with litigation. Its advice on how to prepare for and effectively present a case is unique, well-crafted, and a must-read for aspiring legal writers. It lives up to its billing as, quote, combining the practical wisdom of an incisive Supreme Court justice with the learning of a renowned writer. We have fashioned this portion of the program around an interview format. Award winners, Justice Scalia and Bryan Garner, join us, and that Bill Press now proceed.
You also talk about the importance of appealing to the judge's reason and not emotions. Do you find lawyers trying to play the heartstrings of the judges?
I've just been looking over some briefs to a state Supreme Court in which the full appeal is to the emotions. I mean, it's a jury argument and an appellate brief, and it's a big problem. Even supposedly very reputable firms will write briefs this way. It's a mistake for reasons that Justice Scalia is about to explain.
Well, as I think we say in the book, it's an insult to the court, no matter what court it is, because if the court is a good judge, he's going to be insulted at the thought that you would think he would be swayed by emotional arguments. And if he's a bad judge who is swayed by emotional arguments, he will be insulted because you think he's a bad judge who's persuaded by it. So, you know, it's a non-winner. Frankly, we don't see much of that at the Supreme Court level. Most of the briefs don't even try to do that.
I was struck that actually on page 26 of the book, you talk about, paraphrasing here, about judges who might bend the rules of the law in order to reach a decision that they want to reach that the law might not support, if I can put it that way. No. Were you talking about activist judges?
No names, please. No, I wasn't referring to anybody in particular.
Oh, no, you don't name anyone.
No, there have been, of course, there have been judges like that from the time God made little apples, and there always will be. So what else is new?
And never acceptable, Bryan?
Well, I hope not.
Well, we're actually working on a second book now that relates to judicial interpretation, but what a judge says ought to be grounded in, if it's interpreting a statute, in the words of the statute, or in the Constitution, or in a contract, if it's interpreting a text. But on the other hand, lawyers need to understand that they have to make not just the legal argument, but they have to make the equitable argument. We agree on this, that it's not enough to say that you meet all three prongs of a tripartite test, and just to stop there. You need to make the argument that this is also a sensible resolution, and it's the just resolution in the circumstances. Both arguments are important in almost every case. Would you agree with that?
Absolutely. You are more inclined to accept the valid textual argument when you believe it also leads to the best result. And you're less inclined to accept it, although you should accept it, when you think it leads to a less desirable result.
Justice and Bryan, we just have a couple more minutes, a couple more questions, not in the book, if I may. One of your colleagues retired this year from the bench. Any comments on David Souter as a judge and your experience working with him?
Well, I have sat next to David on the bench for, wow, how long has he been on the court? 20 years, something like that. So I will miss him. He's been a very good colleague, and we exchange comments on the bench now and then. I will miss him very much. He's a very intellectual person. He's well-read. He's interesting. I think he's been the despair of the Washington hostesses because he is just not a social lion, to put it mildly. I will miss him. Many people don't realize that really deep friendships develop on the court, and the friendships have nothing to do with the legal philosophy of of the people involved. Ruth is my best friend on the court, and God knows she doesn't see things the way I do very often. And it's the same thing with David. I will miss him very much.
In 1986, Justice, you were confirmed by the United States Senate by a vote of 98 to nothing.
Right.
Any advice for Sonia Sotomayor?
What was the year?
1986.
Yeah, my advice would be go back to 1986. Things have changed. I mean, I think the reason things have changed is, well, I'm going to get in my lecture on the evolving Constitution, but I think what has happened is that the people between then and now have figured out that under the new theory that the court has been using since about the Warren Court, the Constitution does not have a fixed meaning, but it changes to comport with the times. And when it changes and how it changes is up to the court. Now, once you have that theory, whom you pick as a judge should not depend mostly upon who's a good lawyer, who has, judicial temperament. All that stuff is good. But the main thing you want to know is what kind of a new Constitution is this person going to write? And that's what's happened since 1986. I think I was a good lawyer in the days when that mattered a whole lot. And I think it matters less now, and it's unfortunate.
Justice Scalia, congratulations. Bryan Garner, congratulations. Thank you for joining us. Thank you.